cases, the court finds that under Price versus State, Georgia Supreme Court case that was decided April 19, 2022, the court does find that that is controlling. So, looking at the official code of Georgia annotated under sections 17-10-1 and 17-10 through 17-10-21, the court can look at aggravating factors for sentencing, which include the nature of the crime, the defendant's prior criminal history, and other factors that should result in harsher punishments. In terms of looking at the nature of the crime, such as a vile, horrible, and inhumane offense, crimes involving torture, depravity of mind, or aggravated battery can be considered aggravating. The court can also look at the amount of harm to the victim. In this case, Mr. Perry, the jury found you guilty on all 14 counts. In terms of the amount of harm to the victims, you stabbed, strangled, and tried to smother Pamela Sumter. You raped her, and the testimony was that her injuries were so severe that it was consistent with the trauma of a woman giving birth. Looking at factors such as multiple victims, if the crime resulted in the death or serious injury of multiple victims, in this case, the jury found that you caused the death of both John and Pamela Sumter in a brutal and malicious manner. Also, the court considered the use of a deadly weapon. In this particular case, if a deadly weapon was used in the commission of a crime, this can also be an aggravating factor, such as a knife when used offensively, a pillow which when used offensively, and hands and arms when used offensively can be used as deadly weapons. The court can also consider your prior criminal history. There was testimony that was presented in terms of numerous family violence convictions along with battery convictions. Other factors that the court can consider is a lack of remorse. A lack of remorse or an unrepentant attitude can be considered as an aggravating factor. Mr. Perry, you testified today that you have never hurt anyone, which is inconsistent with the jury's verdict. So as such, in the matter of the state of Kenneth Perry, under indictment number 24-CR-2608, the court will sentence you as to count 1, malice murder. I will sentence you to life. As to count 2, malice murder, I will sentence you to life to run consecutive to count 1. As to count 3, felony murder, that is vacated by operation of law. As to count 4, felony murder, that is vacated by operation of law. As to count 5, rape, I will sentence you to life to run consecutive to count 2. As to count 6, aggravated assault, it will merge with counts 1 and 2. As to count 7, aggravated assault, it will merge into counts 1 and 2. Count 8, aggravated assault, I will sentence you to 20 years to serve in custody to run consecutive to count 5. Count number 9, aggravated assault, I will sentence you to 20 years to run consecutive to count number 8. As to count number 10, aggravated battery, I will sentence you to 20 years to serve to run consecutive to count 9. Count 11, aggravated battery, I will sentence you to 20 years to run consecutive to count 10. Count 12, possession of a knife during the commission of a felony, I will sentence you to 5 years to run consecutive. As to count 13, possession of a knife during the commission of a felony, I will sentence you to 5 years to run consecutive to the other counts. As to count 14, theft by taking, I will sentence you 10 years to run consecutive to count 11, which I believe that is a total of 3 life sentences to run consecutive to each other plus 100 years. Mr. Perry, you have the right to seek post-judgment relief for your conviction of the crimes of malice murder, felony murder, rape, aggravated assault, aggravated battery, possession of a knife during the commission of a felony, and theft by taking. You can do this by either making a motion for a new trial in this court and/or filing an appeal to a higher appellate court. If you want to file a motion for a new trial or an appeal, then you will need to file that said motion or notice of appeal with the clerk of Superior Court of this county, DeKalb County, within 30 days. You may want to more fully discuss this with your attorney, Mr. Queen. If a motion for a new trial is made and the court denies it, you will have 30 days from the filing of the order of denial in which to file with the clerk of court your notice of appeal. You have the right to have an attorney represent you on the motion for a new trial at the first level of direct appellate review, and if you cannot afford to hire an attorney, the court will provide you an attorney and a transcript of the trial at no cost. So with the felonies that you have been convicted of, in a felony, usually you have a period of 4 years from the date of your sentence, which is today's date, March 18, 2025, and this court, when it becomes final, to file a habeas corpus petition. Mr. Perry, do you have any questions for me?
No, ma'am.
Okay, thank you. Mr. Queen, anything you would like to place on the record?
No, Judge.
And does the state have anything that you would like to place on the record?
No, Your Honor. Thank you.
Okay. So we are in recess. Thank you.